Hello everyone, myself Alfonso Jochen. I'm practicing as an environmental law consultant. Today we'll be discussing the module on biodiversity. So the module primarily deals with the international and the national legal framework on conservation and sustainable use of biodiversity. We will be also focusing on three areas, particularly the knowledge and the practices of indigenous and local communities relating to biodiversity conservation and sustainable use, and biodiversity inclusive environmental impact assessment, and thirdly we'll be focusing on biosafety and regulations relating to genetically modified organisms or living modified organisms. So before we begin, let's discuss what is biodiversity. So as the name itself indicates, biodiversity is a diversity or variability in bios, that is, the living organisms. So it has three components mainly. One is ecosystem diversity, the other one is species diversity, and the last one is genetic diversity. So what is ecosystem diversity? Ecosystem diversity simply signifies the diversity in ecosystem. For instance, we have the mountain ecosystems, we have the forest ecosystem, we have marine and coastal ecosystems. So the diversity of the ecosystem is what is ecosystem diversity is, and within the ecosystem, as all of us know, there are different kinds of plants, animals and microorganisms. This is what species diversity is. And as also we know, within the species there are different kinds of varieties of plants. For instance, let's say take the example of rice. We have the basmati, which is a fragrant rice variety. We have the brown rice, we have the white rice, we have certain traditional varieties of rice which have medicinal uses. So the different kinds of species, the diversity within species is called genetic diversity. So these are the three important components, three components of biological diversity. That's the ecosystem diversity, the species diversity and genetic diversity. Now let's discuss how the biodiversity, like this definition of biodiversity, has found its place in a convention called Convention on Biological Diversity, which was adopted in 1992 by in Rio de Janeiro, among the two other conventions on different aspects of environment. So how was the environment, nature, biodiversity, which has been an integral part of life of the human beings, and the use of the biodiversity components, which have been in practice from time immemorial, found its place in 1992 in the CBD, that is the Convention on Biodiversity. And why were the state parties coming together and adopting a convention which will deal with measures for conservation, measures for protecting different types of biodiversity that we have already discussed, and for measures for sustainably using these components. It has, as all of you would have known, the Brundtland report and unsustainable practices, unsustainable ways of development, and also different anthropological pressures to biodiversity due to different reasons like population abundance, population growth, industrial practices, and also intense agriculture practices like monoculture, development projects like mining, dams, etc. has a huge impact on biodiversity loss. And there have been a style that was different from a sustainable way of lifestyle, but developing was an unsustainable practice of extraction of biodiversity components from the biodiversity, which is leading to the biodiversity loss. So in 1992, the nation states gathered together in Rio and passed this Convention on Biodiversity so as to ensure conservation of biodiversity and conservation, sustainable use of its components, and another thing is fair and equitable sharing of sharing of benefits from the utilization of bioresources. So this aspect, the third aspect, is the axiom benefit sharing, which we will be discussing in another module. But in this module, we will be covering conservation of biodiversity and sustainable use of biodiversity. In CBD, let's see in which all provisions this conservation and sustainable use has have found its place. It starts the Article 6, Article 7, Article 8, Article 9 and Article 10 of CBD directly deal with conservation and sustainable use of biodiversity. Article 6 is more or less like a very general provision dealing with it. It says that the states who are parties to this convention, they have an obligation to undertake and develop national strategies, national action plans, programs for conservation and sustainable use, and they also have an obligation to integrate these concepts of conservation and sustainable use into the already existing policies and regulations and programs and plans, etc. So this is Article 6 all about, and let's see how India has responded to this Convention on Biological Diversity. As the national legislation that India has enacted because of its obligation as a contracting party to the Convention on Biodiversity is the Biological Diversity Act of 2002. Most of the provisions in Article 6, 7, 8, 9, 10 have found its place in our Biological Diversity Act also. So India has also developed a national biodiversity action plan that was passed and adopted and passed in 2008, which was a result of a series of public consultation, and also a result of technical report that's called Securing India's Future, which unfortunately did not became the national strategy and biodiversity action plan, but it became a technical report, and the national biodiversity action plan was adopted in 2008 after these series of consultation. This action plan also refers a lot to the conservation and sustainable use that is already there in the articles of the CBD and also the provisions of Biological Diversity Act. So let's see what is the conservation aspects and what are the articles that relate to conservation say about conservation, and what the measures that are required for conservation within CBD. So Article 8 and Article 9 deals with in situ conservation and ex situ conservation. In situ conservation is nothing but conservation of biodiversity in its ecosystem, in its natural habitats, like ecosystems, conservation of ecosystems as ecosystems, and conservation of natural habitats. So for instance, we have national parks, we have sanctuaries, we also have zoos, we have botanical gardens, we have gene banks. What is the difference between these two conservation efforts? One is conservation in its natural environment. So you will have your ecosystem like a national park. For example, you will have the Periyar National Park being protected and managed as in Periyar in its natural environment. But let's say we also have zoos in which tigers are kept and protected. That's something called ex situ conservation. Ex situ conservation is conservation outside the natural habitats of the species or natural habitat. For instance, we have botanical gardens wherein a lot of species of plants are kept and protected and grown outside their natural environment. We also have gene banks where the seed or the genetic component of particular species will be preserved and conserved and kept so that, I mean, especially these genes that collect a lot of diverse species and species that are in the verge of extinction or are threatened. So a lot of species that are threatened or on verge of extinction are conserved through ex situ methods. But CBD says that in situ method of conservation is the primary conservation that need to be done, and even if you are protecting species in ex situ, the ex situ protection methods should be in those countries where the plants are or the species or the biodiversity, biological resources are in the country of origin. For instance, if say if brinjal India is a country of origin of the brinjal, then your ex situ methods of conservation should be within India itself, or a variety whose origin is primarily in India, it should be in India. So in situ conservation is conservation within the natural environment, and ex situ conservation is outside the natural environment. In situ conservation is also with respect to cultivated and domesticated species. For instance, you have rice varieties or chilies, which really don't, chilies, their country of origin is not India, but if you see Andhra chilies have developed a distinct characteristic of its own, then we can call them, and that conservation as an in situ conservation itself, in where they have developed the surroundings, in where they have developed their distinct properties. It's also a method of conservation, in situ conservation. In situ conservation is majorly dealt in Article 8 of the Convention on Biodiversity. The Convention on the Article 8 kind of talk about the various methods of conservation, in situ conservation, and how to address different threats to in situ conservation. For instance, how what about the activities and the processes that kind of adversely impact the biodiversity conservation have to be handled, or the states have the mandate to handle those control those activities. All these things are mentioned in Article 8 also. Article 8 specifically talks about establishing a network of protected areas important for conservation within protected areas important for conservation. It also talks about promoting environmental sound and sustainable development of areas adjacent to protected areas. It talks about how to handle and manage living modified organisms which might have adverse impact on the environment and also on human health. It talks about activities and processes which has adverse impact on conservation and sustainable use. It also talks about Article 8J talks about how to protect and respect the practices and knowledge of indigenous and local communities whose lifestyle have been relevant for conservation and sustainable use. So this is like the main contents of Article 8, and Article 9 deals with ex situ conservation, which we have already discussed. Ex situ conservation is nothing but conservation of species outside their natural surroundings. So if you see how India has kind of adopted these provisions, we already have a wide range of environmental, forest and wildlife legislations. For instance, we have the umbrella legislation of Environmental Protection Act, which deal with environmental impact assessment of development projects. We have an EIA notification in 1992, which is now re-notified in 2006. And we have also rules regulating the biosafety, rules regulating the genetically modified organisms, which was passed in 1989 under the Environmental Impact Assessment, Environmental Protection Act. We also have pollution laws relating to air pollution, water pollution, and what to do with all those pollution that have created from industries and other activities. As already discussed, the Biological Diversity Act is a primary act that kind of deal with all these things, but a lot of its provisions have already been addressed in different legislations. For instance, we have established a network of protected areas under the Wildlife Protection Act in 1972, and we have different protected area categories like national parks, sanctuaries, community reserves, conservation reserves, and also other areas that are demarcated for conservation of different species, like we have tiger reserve, we have programs, different programs for elephant conservation, we have tiger reserves, and there are other policies and laws, regulations which deal with conservation. For instance, we have certain legislations for or policies for wetland conservation, etc. So we already have enacted a network of conservation laws, that is for under the Wildlife Protection Act, which has categories of protected areas like national parks, sanctuaries, conservation reserves, community reserves, and the categories of demarcated areas for protection outside this network of protected area, because Wildlife Protection Act has a definition for protected area. But we have elephant reserves, we have tiger reserves, we have other protected areas, and also we have different policies for conservation, like we have wetland conservation policies and etc. So we already have a set of rules and regulations and legislation that address a lot of aspects that is there already in Article 8, and also the provision, the sections in Biological Diversity Act. So, but now what we need to look at is what is a kind of a type of approach towards conservation in all those wildlife laws. It was earlier when you say we had categories of protected areas like national parks and sanctuaries. So, when you establish a national park or sanctuaries, it was you never went and asked for consent of the communities that are living there or that are being protecting these areas. So you the provisions were like you notify that area and then you settle all the rights, which basically means that the communities living in those areas will not continue to enjoy those rights. So they have to be relocated, their rights have to be settled, and they have to be displaced. While this system of conservation or approach of conservation was exclusionary in nature, and it was a top-down approach. This has been really criticized in by many, and the approach slightly shifted, and we have adopted joint forest management. We have adopted new categories into the protected area definitions like community reserves, conservation reserves. We've already also passed a legislation which is the Scheduled Tribes and the Other Forest Dwellers Recognition of Rights legislation, that is known as the Forest Rights Act in 2006. This legislation kind of give the tribal communities their right to depend and live in the protected areas, live in the forest, live in continue to use their the resources for their livelihood and also for their some kind of other uses. And also it gave them the right to protect and conserve and manage those forest resources that they have been traditionally conserving. So now you just don't have you have both state control over the protected areas, and you also have provisions for communities conserving the certain areas, which we already know that it includes your conservation reserves. It includes your community reserves, which is basically private lands. It also includes community forest reserves, which is a right that the forest dwelling communities have obtained from the Forest Rights Act to conserve, protect, manage the forest resource. And another thing, another protected area kind of classification can be found in Biological Diversity Act, that is for biodiversity rich areas. You can notify those areas as biodiversity heritage sites. So we already have all these protected areas, and now we have a slight change in our approach also. From an exclusionary approach towards conservation, we are kind of including communities who have been already protecting these, and now it has become an inclusive approach towards conservation also. So that's how the conservation aspect of our of the Indian legal system goes. Now when we talk about sustainable use of biodiversity, what is sustainable use of biodiversity? Sustainable use of biodiversity means the use of its components in such manner and at such rate that it does not lead to long-term decline of biodiversity, and thus thereby maintaining its potential to meet the needs and aspirations of the present and future generations. So that is what sustainable use. So this sustainable use is elaborated, and elements of sustainable use is elaborated in Article 10 of CBD, and it says that we have to integrate these consideration of conservation and sustainable use of bioresources into national decision making, and we have to also support communities who have been customarily conserving and traditionally using this using the biological resources in a sustainable manner, and various ways of including customary use, sustainable use and different policies. All these things are mandates of the state governments, the national governments, to incorporate it in its decision making. So the convention has also adopted a voluntary guidelines called Addis Ababa Principles and Guidelines, which has 14 principles, which also have supportive, which also mentions that you need to have supportive policies, laws, institutions in order to effectively link all the governance level for sustainable use, and it has 14 principles, very relevant. This is also incorporated in our India's legal system. We have the National Biodiversity Action Plan talking about sustainable use of biodiversity. We have also included a lot of a lot of policies and incorporated the sustainable use into these policies. For instance, we have our conservation strategy and policy statement on environmental and development. We have the environmental policy of 2006 National Wildlife Action Plan. All these recognize the sustainable use of biodiversity. But also we have the important legislation that deals with conservation and sustainable use of biodiversity is the Biological Diversity Act, and under the Biological Diversity Act, the National Biodiversity Authority and the State Biodiversity Board, they have the right to restrict and prohibit activities that are relating to biodiversity related activities on the basis that these have impact on the environment, these are unsustainable, etc. So that is a provision that's already there in our legislation. Now let's go to the focus areas. One is Article 8J related to Article 10C, which means how to protect the knowledge and the practice of indigenous and local communities associated and the practice associated with conservation and sustainable use of biodiversity. When you say that, we can find that there are not too many legislations available in India. So the Biodiversity Act has two components, that's like the section 36(5), which says that the state government has to develop measures so that there will be sui generis protection for registration of local people's knowledge of biodiversity. So, and also we have section 41C, which mandates the biodiversity management authorities for documentation of knowledge relating to biodiversity, also it for conservation and sustainable use, and also these are somewhere linked with the, you can link all these provisions with the indigenous and local communities right under Article 8J and Article 10C. We also have under Plant Varieties Protection and Farmers' Rights Act, the farmers' varieties that can be registered and benefit sharing can be done. So these are the some areas relating to protection of indigenous and local communities, right? But not really, we don't have extensive areas for that. But also the Traditional Forest Rights Act can also be viewed as a tool to kind of integrate this particular right of indigenous and local communities. Now I move on to the Biodiversity Inclusive Environmental Impact Assessment. So under Biological Diversity Act, you have the central government again has a mandate under section 36(4)(1) to kind of adopt measures to undertake EIAs which are likely to have adverse effect in biodiversity, and to kind of avoid or minimize all this adverse effect, and with the participation of local public and the local communities for such assessment. We already know that we already have an environmental impact assessment regulation under the Environmental Protection Act, and in the regulation we have a special provision relating to sensitivity of biodiversity, wherein the project proponent has to mention all the biodiversity related components in those areas where he wants to build a project, and also kind of like say what are the mitigating measures that he is adopting for that. And these in the EIA, the authorities will consider and appraise this information while they are granting environmental clearance. In addition, we also have an additional level of protection when we deal with development projects in protected areas like national parks and sanctuaries, because in those areas it's not possible, and it is if you need a environmental development project, environment clearance in those areas, you need to submit it to the National Board for Wildlife, the Standing Committee of National Board for Wildlife. You need a clearance or recommendation from the wildlife. Then it also has to go to the Supreme Court. All these are by-case laws, and there is such additional protection for biodiversity inclusive environmental impact assessment in India. Now let's deal with biosafety. As already mentioned, India has passed rules for biosafety, for regulating living modified organisms or genetically modified organisms or hazardous substance under the Environmental Protection Act. The Biodiversity Act also has a provision relating to it under section 3642, where it is a mandate of the central government to make provisions for governing the use and release of living modified organisms. So the rules of India, that is rules for manufacture, use, import, export, storage of hazardous microorganisms, genetically engineered organisms or cells, 1989, kind of establishes 6 authorities or institutional bodies for regulating all these activities relating to living modified or genetically modified organisms, in which the Genetic Engineering Appraisal Committee is the most important body, and you cannot undertake any activity like import, export, transport, manufacture, a number of activities without the without approval of Genetic Engineering Appraisal Committee. So whenever biotechnology companies want to buy a genetically modified organism, for example, if you want to develop a CRY gene, that is a genetically modified gene, or import a CRY gene, you need the permission of Genetic Engineering Appraisal Committee. If you want to develop a genetically modified cotton, you need approval of Genetic Appraisal Committee. The committee will appraise the information and look into all the provisions that are related to the risk that are associated with this, and then on that they will give approval, and sometimes will not give approval. So we already have those things in place. Also, this under the convention we have the Cartagena Protocol, which deals with biosafety. It also look into transboundary movement of living or modified organisms, transit and handling, and it also needs certain procedures, which is like you need the person who is sending the living modified organism need to appraise the country who is receiving it, and you need the permission of the states into which it is imported. So all these regulations are there again in Cartagena Protocol. We are also a signatory to Cartagena Protocol, so we also have the obligation under the Cartagena Protocol dealing for safe handling of living modified organisms. So these are the topics that we have covered today. We have discussed what is biodiversity, we have discussed the conservation and sustainable use of biodiversity, what are the international and the national framework, and what are the measures that the nation states have to kind of adopt under its obligation under the international framework, under the national framework. Also, we have discussed special focus areas like indigenous and local communities' right to protect, also customary use of biodiversity. Also, we have discussed the biodiversity inclusive environmental impact assessment, and we have discussed biosafety regulations. So I think it was a informative discussion. Thank you.